Wealth is a Choice podcast. Boom.
Let's listen to it. Let's listen to it.
Hey,
How are you?
I'm doing good.
Well, good.
So I want to ask you about some estate planning, gone right and gone
Yes.
wrong.
Yes.
I've seen it gone wrong a few times.
It can.
So one of the things I see happen is sometimes siblings can get a little bit, I don't want to say crazy.
Mm-hmm.
So I had one situation that not that long ago where, and you see this was multiple siblings, there were about 4 siblings. And usually in an estate plan, somebody's in charge. Mm-hmm. Sometimes they put 2 people in charge. So in this case, there was 1 person in charge. And the other 3 siblings didn't want to be in charge. They weren't listed. Mm-hmm. And when it came time to actually getting the work done, they didn't really care. They didn't want to do it.
Sure.
And the one sibling was doing the majority of the work. Mm-hmm. And it wasn't a huge estate, but there's some money, there's some property, and there's some belongings.
Okay.
So he had asked for a bunch of help, according to him, and wasn't getting it, and came down to the belongings and tried to see what everybody wanted, wasn't hearing back from anybody. He goes and has an estate sale, and then the siblings find out that there's an estate sale going on, and they show up furious. By the time they got there, half the stuff is gone or whatever, according to them. And here goes on the fight.
Yeah.
And they think that he is absolutely wrong for doing what he did and underhanded, and they say that they weren't informed or whatever. He says, I told him, ask for help. Nobody ever showed up. Yeah. So I finally did it. He lives out of town and a long ways away. It's not easy to do this stuff.
Right.
It can take a year or more. And then the attitude now is, from some of the siblings, they don't care if they end up getting any money at all. They don't care if all of his inheritance goes toward legal costs.
Okay.
Yeah.
Yeah, unfortunately in the law we use the word reasonable often. And I think this is one of those situations where reasonable is important. The person administering the estate has a fiduciary obligation to duty of loyalty to the beneficiaries, right? They have to carry out their orders. One of those things would be to sell or distribute personal property. If the trustee, for example, has made a reasonable effort to contact the beneficiaries, hey, next Monday we're all going to get together, or the 3rd Saturday of this month, be prepared with a U-Haul. Meet us at the home, because if you need anything big, this is your chance to get it. And you kind of get everyone on the same page, then you've made a reasonable effort. And if nobody shows up, by all means, have an estate sale. What doesn't sell, donate. What doesn't donate, scrap, right? That's the process. The situation you just kind of laid out would be, did that person, what sort of effort did they make to get everybody together? And if it seemed like it would be what the ordinary person would respond to and do, then that's perfectly fine. But if it's a text a day before, hey everybody, meet me at Dad's house at 7 o'clock tomorrow night and bring a U-Haul truck if you can, that's not the reasonable way to go about things. So the individual who was doing the administration may have done the right thing, just depending on the type of effort they put into getting in touch with the other beneficiaries.
What does somebody in that situation, what do they do to archive? You think about siblings, like a lot of times there's 8 kids in my family, and I don't think, who thinks they're going to get in a fight with their sibling?
Right.
And so you go about with this trusting relationship that you've had maybe your entire life, and then all of a sudden that's not it.
Right.
And so you don't, like if I was dealing with a bunch of strangers, well then I'd probably have archived all of my actions.
Correct.
In correspondence and all that stuff. But you're dealing with family.
Yeah.
That's usually loving and just fine.
That's the assumption.
Yeah.
Unfortunately, I think what we see is death brings out the worst in the family.
Yeah.
And a lot of times it's the siblings were maintaining a relationship while mom and dad are alive. But when mom and dad have passed away, then the gloves come off.
Why is
so
that?
now, I mean, greed is an
Yeah.
easy answer, right?
Okay.
It comes down to money.
Okay.
And I do think it's some children feel like mom and dad like this one better and did more for them than they did for me, and they've been harboring these feelings.
Okay.
And now is their opportunity to let those things go. So it's interesting you say when you're dealing with kind of non-family beneficiaries, that's actually an easier administration than dealing with family.
Okay.
And so when I'm counseling someone, a trustee specifically, on doing administrative work, copious notes. Accounting is essential. Every receipt, everything you've done, track all of those emails that you sent to the family, be here on Wednesday to look through the personal property, keep the follow-up email, keep the text, keep all of that documented. So if someone were to contest what you've done, you have notes, you have accounting records, you have emails, you have texts, you have everything you need to show that you've done what you needed to do.
So like in a trust document, you identify who a trustee is, but I've never seen an instruction at the back of the book that says, hey, trustee, now here's how you go about your job.
Yeah, most estate planning attorneys like myself, we will give a checklist.
Okay.
Now, it does within the trust describe their obligations. You have to pay all legally enforceable debts,
Right.
funeral burial, right? Those sorts of things. But I think what you're talking about is, how do I know that I need a tax identification number?
Yeah.
A post-death certificate of trust?
Right.
Those sorts of documents.
Or even how do you track expenses?
Right.
You put it all on a credit card so you can pull it up later,
Yeah.
you can show the receipt, or you putting it in an Excel program.
I think there's no right answer. I give my clients an Excel sheet and tell
Okay.
them to populate this Excel sheet.
Okay.
And keep all of their expenses within an Excel doc. Some of my clients are always very ahead of the game,
Okay.
and they will have those sorts of things already in place. There is a checklist that I provide. You need to do this, you need to do that, but it isn't intuitive.
Okay.
If this isn't something you do for a living, you may not know how to get a tax EIN.
Okay.
And so typically, this is when a trustee needs to involve an attorney, financial advisor, to kind of help with that process.
Is it expensive to settle an estate? So let's say somebody's worth, say, $400,000 in, cash retirement plan, whatever. And you've got, a $300,000-$400,000 house and maybe a mortgage that has to get paid off or whatever. You've got a funeral and some legal costs and stuff like that. So what would a trustee be embarking on when they start this process?
So they're dealing with the funeral, they're dealing with the burial, they're continuing to pay the utilities while the house is ready for sale, they're getting dumpster to clear out the garage, they're meeting with the real estate agent, right? They have a list they have to go to the bank. They have a list of things they need to do, but it's not a huge lift. I like to tell people it is a paperwork exercise. It is a massive paperwork exercise, but it's not unusual for trustees to track their hours, which they are reasonably.
Yeah. How often is that? I know every trust I've seen that you have the right to charge.
Correct.
How often do people do that?
So when I'm helping somebody with administration, the first thing I tell them is, by law, you are entitled to reasonable compensation, so please track your hours. Mm-hmm. When the trustee is not a beneficiary, they don't have skin in the game, I will see them track their hours, okay? When it's typically a family member, 3 adult children, one of them is acting as the trustee, I will often hear, this is what my mom and dad wanted me to do, I'm not gonna track my time.
Right.
And my response to that is, track your time, because it is a lot of legwork. So why not compensate
Usually
yourself?
it takes months, and a lot of times carries over into the following year, the final tax return and all that
if it's not a super in-depth administration, I think anything more than a year is a long time.
Okay.
If you're selling a home, you're having a hard time selling a house, that's a different story. But typically, a normal administration, no more than a year. Anything after that, what we start to see is people are I can't give away these personal assets. it's affecting me too much.
Yeah.
I don't want to clear out the garage because Dad's woodworking stuff is in there.
Right.
Well, now you're getting in a position where you're not meeting your obligation.
Yeah.
So a lot of times when these things stretch out, it's because they're letting personal feelings get in the way of doing the administration.
Yeah, and that could be coming from one of the siblings that
Yeah.
isn't involved or
Yeah.
isn't on the document to be responsible for it.
Yeah.
They could be,
Comes from all sorts of
Holding it up,
people.
yeah.
Yeah, it could be the trustee, it could be other beneficiaries giving, how are we going to
yeah.
donate mom's clothes? Well,
Yeah.
because no one's keeping them.
So in this case where it's coming down to, it just looks like a upset, legal fight where they
Yeah.
want everybody to be harmed.
Yeah.
Maybe best avoided if had kept copious notes in
Correct.
and on communication
Correct.
and everything. And this is one of these cases where I heard a bit from all parties, and so I don't know if he communicated like he thinks
Right.
he did. I don't know if she didn't get any responses to anything. I don't know if she didn't do anything.
Right.
You're just hearing what everybody says.
It-
But if there was a paper trail
Correct.
of communication, it'd be there. And I don't think there is.
That would be the first step.
Yeah.
Another thing would be to get an attorney involved. They're not going to act as the trustee, but they can assist in reaching out to the
Well, I
beneficiaries.
think a bunch of attorneys are involved now.
Yeah. Yeah, well,
I think they
before
all
it
got
gets to
one.
that.
Yeah.
Way you have an attorney who can say, yes, this is the steps that the trustee took.
Yeah.
And so, in a sense, you're also letting the beneficiaries know as well, too, the trustee has met their obligations. You now are becoming the problem, not them, and we
Yeah.
can document that they've done everything right. So,
So a trustee, they, a lot of people, being a trustee might be their first time.
Yeah.
They could be a trustee of a trust. They could be what, executor of a will,
personal representative of an
a
estate.
will.
Yep, yeah.
So whatever name it is, in whatever form of the estate plan or lack of estate plan that was put in place,
Yeah.
the person responsible for facilitating the distribution
Yep.
of the assets, if you will,
Yep.
unwinding of an estate.
Mhm.
If they need professional help, they go hire professional help.
Yes.
But all of this stuff, obviously, track it, Excel spreadsheet. The better
Correct.
organized you are,
Correct.
the more clearly you can communicate.
The more copious notes you have, the better situated the trustee or the personal representative is.
Mhm.
Absolutely.
And you share those notes ongoing throughout your process?
No,
No.
I wouldn't share anything unless necessary. Now, in accounting is a different story. And accounting is required by law. The trustee must provide that to the beneficiaries so they can see financially what took place.
And how
But, yeah.
often? At least annual.
Annually.
But people do it monthly, kind of a...
So, again, we look at that reasonable request, right? Is it reasonable to request from a trustee an accounting of assets every week? Absolutely not. If you're taking care of the administration within 1 year, usually one time is
Okay.
when we're getting
Right
ready
in the
to
very
make it.
right in the very beginning?
Well,
and
we
then-
do an initial
Okay.
accounting of assets, and then when we're ready to make a distribution, then the final accounting comes out. Typically, I don't see too many requests made in between.
Mm-hmm.
Again, if you're getting into this has been going on for 3 years, then you may see beneficiaries asking for a little bit more of an updated accounting.
Okay.
Yeah.
All right. So another case not that long ago, 2 siblings, and one sibling did all the work, which I don't know how often you find that to be common. So they're co-trustees. So
Okay.
either one of them could have done
Okay.
as much work as the other one. But
Yeah.
for whatever reason, one does basically almost all the work, meticulous job
Mm-hmm.
of it. Toward nearing the end, the other one kind of loses it,
Sure.
like out of nowhere.
Sure.
And I don't know if it's like a sudden loss of control, childhood stuff. Maybe they're a little bit narcissistic in the first
Yeah,
place. Like, I don't know
yeah,
what's
yeah.
going on. But then files a lawsuit. And now this other sibling that's done all of this work is sitting there defending themselves
Mm-hmm.
in, with an attorneys.
Yep.
And then eventually with a judge.
Yeah.
And along the way, the accusations
Right.
are horrendous.
Correct.
And you can say whatever you want to say.
Yes. Yeah.
And you can file whatever you want to file.
Correct. Correct. So again, this gets back to the keeping notes,
Okay.
keeping accounting records. The reason a trustee, a co-trustee may challenge what another co-trustee has done would be they feel like they misappropriated money. They commingled money with their own. They're using trust money to do massive upgrades on the house, but there's really not going to be a benefit in doing something
Right.
like that. So those sorts of things certainly can be questioned.
Yeah.
But you really, as the trustee, need to protect yourself
Yeah.
and say, I met with a real estate agent.
Yeah.
Here's what they said the home is worth. If
Well-
I put a new kitchen in and if I do this, we're
Right.
going to be able to sell for X, so the $10,000 we put into it's going to yield back 40. That makes sense. But that needs to be documented.
In this case, notes in meticulous, everything was great. It's so obvious. Eventually, the judge just had to bring an end to it,
Yeah.
which was great. The trust document. Here's a case where the estate trust documents helped because they provided the framework.
Yeah.
This is what's supposed to happen.
Yep.
Blah blah blah. And
Yeah.
you don't go outside that framework.
Correct.
It kind of is what it
Correct.
is.
You have certain obligations and duties, and as long as you
50% there, 50%
Yeah.
there. I mean, it's pretty straightforward.
Yeah.
But
But again, something like dragging your feet.
Yeah, the accusations were so obviously wrong, and everybody understood it.
Yeah.
Including the judge, and it brought it to a close. But it took a year.
Right.
It took a year to do all that.
Right. Right.
And I don't know in that situation if it ever could have been avoided
No.
at all.
Some people are just bent on creating problems.
Yeah.
And like you said, anyone can create problems. It's
That
the world
blows
we
me
live in.
away.
That's
so
the
I
world
always
we live
thought
in.
this
Yeah.
perjury is sacred
Yeah. Right.
under penalty of perjury law.
Correct.
These
Correct.
things are true.
Correct.
I-
Yeah. We see that very, very rarely enforced, right? And all sorts of accusations made,
Yeah.
and people don't seem to be held accountable
Yeah.
for what they throw out there.
Yeah.
But this is kind of the world we live in. Yeah.
So kind of in that case too, where when it comes to money, money's black and white.
Mm-hmm.
I mean, you got $1 here, 50 cents, 50 cents.
Yeah.
Real estate's more complicated.
Yeah.
What's it worth?
Correct.
Who says what it's
Yeah.
worth?
Yeah.
Is it a good appraiser? Is it
Correct.
appraiser playing games,
Yeah.
trying to change the price of something?
Right.
Did the home get sold among family? Or did it get sold, to a third party?
Right. Those are all options.
Yeah.
Yeah, and I see all of those. One of the things I encourage trustees to do is to get a good certified appraiser for that home, have a report done, engage a real estate agent as well, see if maybe what this appraiser would list the home for is consistent with what the real estate agent would do. So now you have some documentation as to how you came up with your number. And if that is going to be the number you're going to sell the home with, great. That's also the number that a beneficiary can purchase the home for too.
Right.
So we see trustees getting themselves into problems when they want to cut little brother, a beneficiary, a deal on the home. Because the other two siblings are not benefiting from that. You're benefiting one child. So the trustee has to be careful when they want to do something nice, when they really have to approach this as if they are a non-involved third-party person, don't have any relationship with these people, and I'm going to follow the law like I need to. Yeah.
Yeah.
Yeah. So appraisals are a big, big deal when it comes to homes.
They are.
Yeah.
Now, you probably remember back in 2008, appraisal companies were doing all kinds of stuff
Sure.
to inflate the value of property or,
Yeah.
to qualify for mortgages. So I think that's gotten buttoned down quite a bit. But I saw one a couple of years ago where one side did an appraisal and had 6 different comps, all comparable, no adjustments. The other side did their appraisals,
Yeah.
had 3 comps, all with adjustments, not the same type of property, waterfront versus not waterfront, blah,
Correct.
blah, blah. And the year of the comps were 2 years after the sale of the property. So I was kind of surprised to even see that.
Yeah.
Because I thought after 2008,
Yeah.
that industry got a lot tighter.
Well, you have to wonder, what is the motive for that appraisal?
Yeah, to
It's
change
not
the value.
To change the value, and not
Yeah.
even appraise. It's not even a waterfront. You're acting like it's not a
Right.
waterfront home,
Yeah.
but it is a waterfront home.
Right.
It's in my opinion, that's probably something they're trying to do kind of a handshake deal to a friend who's going to buy this home, and they're
Yeah.
trying to deflate that price.
Yeah.
But that is how a trustee gets into trouble.
Yeah.
Is when they rely on that sort of an appraisal that we know doesn't meet what it needs to,
Yeah.
versus a real certified appraiser who did it the right way. The trustee is going to rely on this other one, and that is problematic for them. And
Yeah.
that just leaves beneficiaries the opportunity to say this trustee didn't follow what they needed to follow.
Right.
They breached their fiduciary obligation to their beneficiaries.
Yeah.
Yeah.
And then hopefully they have enough wherewithal to understand that.
Yeah. Yeah. Hopefully.
Yeah.
Not always.
So I see a lot of times where siblings, they may be best friends, maybe not best friends. Maybe they get along, they're siblings, but maybe there's no great bond there. And then when the parents are not there anymore, sometimes that fracture becomes obvious.
Absolutely.
If one of them more than the other or whatever. But I have seen big family scattered all over, the country. Trustee, well organized, meticulous notes, all that stuff. Organized all the property in the home. Had color-coded tags on everything. You know what I mean?
Went above and beyond.
Yeah, people could go in and choose what they want.
Yeah.
Siblings and grandkids after and blah, blah, blah. And one sibling, again, we don't know, you don't know how people are going to respond after their parents pass away. There's a lot of
Correct.
There's a lot of stuff that goes on.
Correct.
You'll be a great person. You can go through a lot of grief.
Yeah. Yep.
And you don't know what that grief's going to turn out. Anyways, this sibling's coming into town in a mood. The other ones get wind of it, and they gather up the more valuable stuff.
Yeah.
Because she comes into town with basically a U-Haul and goes and grabs tons of stuff out of the house.
Yeah. Doesn't work that way.
No.
It's not supposed to work that way. No.
But what is it like? I mean, what would somebody do? I mean, I think it was smart of them, and they communicated well with the other siblings. Like, hey, so-and-so's coming to town, and I talked to them, and they're riled up. I'm going to go take this thing. So it wasn't like it was one person out of 6 of them, trying to pull off a fast one. They're like, I'm protecting everybody real quickly.
Right.
But what is it?
Well, what it really boils down to is, if you had 4 beneficiaries, for example, they are equally entitled to the value of that personal property.
Yeah.
So that's where a trustee really, if there are going to be potential issues with a family, bring all the jewelry to a jeweler, have it appraised. Have the baseball card collection appraised. Have the vehicle appraised. Have everything documented. And if somebody wants to come in and take all of mom's jewelry, great. But we know that jewelry was $40,000 and the rest of us got a couch and a chair.
Yeah.
So now you are going to get less cash
How
because
often do
you took
see
$40,000 in assets.
How often do you see a detailed inventory of the stuff in the house?
Not often, and the reason being is people don't typically want their parents' personal property. The few things that I see are mom's jewelry is usually one that people are interested in, and other than that, very little.
Okay.
My experience is most people are bursting out of the seams of their own home.
Okay.
They can't take mom and dad's things on. Yeah.
Okay.
So it's really more so the grantor, the person who's creating this, their personal property means so much to them, but it doesn't mean much to the kids, is really the way I see it.
Okay.
Yeah, I had an example where I met with a gentleman. He was really into woodworking. This was his life. He had a pole barn with all of his equipment in it. And he was adamant that his son take this woodworking equipment.
Okay.
And his son is in the room saying, I don't want it.
Yeah.
So get rid of it now. And he just did not want to part with this. And they
Yeah.
were upfront with their father saying, we will sell it when you die.
Yeah.
Because, again, my experience is most people are just not taking parents' stuff.
Okay.
Yeah. Very rarely.
Yeah. So what about this? I've seen this a couple times, and this a little different from that, where sometimes, you get something from a grandparent or a parent, it reminds you of them, mementos.
Yep.
So I've seen it a few times where you draft a document to distribute money after both people pass. And I've never seen a document that has any instructions about after one person passes. I haven't. Maybe you've written them this way.
Yeah.
But I have seen sometimes where the remaining surviving spouse cannot part with their spouse's stuff, even though it's sitting in a closet.
Yeah.
And the kids get zero memento,
Yeah.
things to remember their parent by, and this could go on for years and years.
Yeah.
How often do you see something like that? And is there anything is that any discussion you have with people while they're drafting a plan?
Yeah, so when you are looking at a traditional husband and wife, what you have to understand is, even though the wife may say, hey, if I pass away, I want my wedding ring to go to our daughter.
Right.
It's not the daughter's. That is a joint revocable trust.
Right.
So it is the husband's property at death.
Right.
That may be her wishes, but he does not have to follow those wishes.
Right.
Right? And so...
Does he ultimately have to? He can't sell that ring to somebody else?
He sure could.
He could.
Absolutely.
Even though it says?
Absolutely. Just like when one spouse passes away, the surviving spouse can amend a trust. It's not irrevocable upon the death of both of them. That applies to personal property as well, too.
If there are two separate trusts?
That's a different story.
If it's one
Correct. If you had
trust?
Correct. If you have individual trusts, you can direct things that you own in your name at your death.
Okay.
If you have a joint trust with a husband and a wife, nothing is set in stone until both of them have passed away.
Okay.
Yeah. Yeah, so we will often see a surviving spouse not want to get rid of things because it means too much to them, even though mom wanted this to go to their child. Right. Eventually, it will get there because it's very unusual, right, that they're going to remarry and use their deceased spouse's wedding ring for their new spouse.
Yeah.
But ultimately, it does seem to go that way, but it may take another 7 years before we actually see that come to fruition.
Wow.
Yeah.
Aside from a completely separate trust, is there any document that is more concrete in that?
So I would think if you wanted to bypass a trust and have your own individual will where you have designated personal property within the will, that will could be probated and it would force that property to have to go to that person. But again, now you're going through a probate process to make sure that mom's, bracelet goes to little Johnny because dad doesn't want to give it to him.
But in a trust document, you can't just simply say, if I die before my spouse, I want my son, to get my watch.
Well, you can say it, but it doesn't mean the surviving spouse has to do it because that trust is always amenable and does not become irrevocable until they both have passed away.
Yeah.
So you can change anything in it.
Crazy.
So the only
I didn't realize that.
Yeah, so in a joint trust, the only concrete way would be to literally specify something in a will and make it a probate issue when one of the people dies.
But then even then, so this is going to bring up another big point. Not all the beneficiaries are always aware of what has been given to them.
Or what has not
Right.
been given to them in some situations.
Yeah.
Yeah, well, this is where the trustee has a fiduciary obligation to provide notice to all beneficiaries of what their interest in the trust is.
They have an obligation, but it could be criminal.
What do you mean? It could be criminal.
So here's a horrible example.
Yeah.
We'll call the guy Peter. Was representing himself as the trustee of one of his deceased clients.
Okay.
He's an accountant.
Okay.
And, but he wasn't the trustee.
Okay.
But he was the accountant for
Okay.
years. He was a successor trustee, if need be.
Was there someone
He
named
had
before
power
him?
of attorney,
Okay.
being the accountant.
Okay.
You know, his sister was actually listed as the trustee, and she wasn't aware of it.
Okay.
Sometimes that happens.
It can.
Trustees don't know that they've been listed as a
Correct.
trustee.
Correct.
Great communication.
Yeah.
But it happens, and so this is a situation where I kind of got involved because I was managing one charitable account within the estate. And I didn't know anything about the rest of the estate, but I was managing one charitable account. But at one point, I saw a statement, and this is, you know, well over a year after she had passed away, a year and a half. And I saw a statement, not part of the charitable account, that had money in it. And I asked Peter if he had, you know, distributed everything yet, still assuming he was a trustee because he was on the charitable account.
Okay.
And he said that he had, and the charitable account was the only one that hadn't gotten done. But I contacted the estate attorney to double check on some things with the charitable account, and in doing so found out that he's not the
The
primary
actual
trustee.
Yeah.
His sister is. So I called the sister, who hadn't heard of anything, and I asked her to go meet with him and pick up some documents and stuff, which she dropped off, and come to find out he had embezzled a lot of money,
Okay. Yeah.
over $1 million,
Yeah.
and was supposed to give the money to his deceased client's siblings that lived out of state, and hadn't given him very much at all relative to how much was in there.
Yeah.
So thankfully there was still some money left, but here's a case where the deceased siblings had no idea
Yeah.
that they were listed, had no idea that they were inheriting all of this money,
Yeah.
had no idea who the proper trustee was, and he was the accountant, so it kind
Yeah.
of seemed normal that he would be.
Yeah.
And he got away with this thing for a very long time.
Yeah.
You know, the FBI prosecuted him, and he died of a heart attack before he could be sentenced.
Okay.
You know, but
Yeah.
but a lot of money wasted,
Yeah.
a lot of money gone.
Yeah. So one of the benefits of a trust is its anonymity post-death. You like to keep your affairs private. One of the downsides of that is exactly like you described.
Yeah.
The family may not know about it because there is nothing in the public record.
Right.
Now, I always encourage my clients to share their estate plan with their successor trustee, with their financial power of attorney, healthcare power of attorney, those fiduciaries who may be acting, so they may have just an electronic copy of it, but they know what's going on.
Yeah.
In that situation, the individuals who created this estate plan shared nothing.
Right.
And
It
so
very
they,
intentionally so.
they put their family in a bad position because they didn't know. They unfortunately had the worst possible series of events happen. Someone who wasn't legally allowed to act as a trustee decided they would. The individuals that were beneficiaries did not know anything about it.
Right.
The only way they're going to catch wind is if they somehow catch wind, right? And then their recourse at that point is to hire an attorney, and this individual who acted unlawfully is subject to civil and criminal penalty, right, for doing something like that, but you have to be aware of it.
Right.
And so, again, sharing that estate plan with loved ones, with those fiduciaries, trustees, powers of attorney is critical so those sorts of things don't happen.
Yeah.
Yeah.
In this case, I was really surprised at how difficult it was to even have him prosecuted.
Yeah.
The FBI wanted to see a certain financial threshold met
Okay.
before they would get involved. And it took a bit of detective work
Yeah.
to even determine from my end how much money it looked like it had been lost. Because I
Yeah.
hadn't, I wasn't overseeing any of these accounts, so it was
Yeah.
a little bit difficult.
Yeah.
for me
And
to
it
get
would
record
be
of
interesting
it.
to know what your obligation would have been if you had been aware of the accounts and knew that the individual who was acting was not the actual trustee, if you had any sort of obligation to inform those clients as to any wrongdoing, I don't know.
Yeah.
But you would think those are the sort
You
of
mean
way,
like if well, so here's the deal. So I was calling some of these investment managers, telling them, listen, he is not the trustee.
Right.
He is this, he's that. And so this is so weird. They were giving pushback in the beginning. They're managing still the remaining. It's creating a lot of money for them.
Sure.
And they were hesitant. They didn't,
Yeah.
honestly, it was weird. And I just point blank, like, listen, this guy's committing fraud. He's
Yeah.
stealing. You don't want to
Yeah.
be part of that.
Yeah.
And they were a lot easier to deal with. But their initial reaction was that things are working all right.
Right. He had produced documentation when the individuals
Yeah.
passed away post-death that
He
put
showed
him
his
in
power of
charge.
attorney.
Yeah, he showed
had
the
that
post-death
document.
certificate of trust and
Yeah.
things, but he should have never had those prepared.
And they didn't do
so-
a very good job of confirming that he was a trustee. They saw the
Yeah.
power of attorney. They didn't do a lot of research on it. And then they let this thing go on for a year and a half.
You know, it's interesting because people don't understand that when the grantors pass away, part of their estate plan when they're creating a trust is a certificate of trust while they're living.
Right.
But when those individuals pass away, a post-death certificate of trust must be prepared. That is what the financial institutes now hold their hat on.
Okay.
Okay? I often see financial institutes not requiring the post-death certificate of trust. So how would they know if that trust had been amended 5 different times? If the trustee had been changed 5 different times? That financial institute would not, because they're not
Correct.
looking at the right document.
Yeah.
So they're not doing their due diligence.
Yeah.
So there's
And it's tough.
failures along the
And
way.
it's
Yeah.
probably difficult to do. But
Yeah, I mean, they should be doing their job.
Yeah.
You know, when I see clients funding a
Yeah.
trust and adding a trust as a TOD on a checking account, oftentimes the bank won't even look at their certificate of trust, which you really should be looking at that.
so on that, just last week, I was meeting with a financial advisor. She's down in Indiana. And she got some funding requests to do a TOD to a trust on one of her clients' accounts. Her client's basically blind.
Okay.
And the attorney had set himself up as the trustee and beneficiary of this person's account.
Wow. Yeah. So.
But she read through the entire document, saw what was going on, had the verbal communication with her client to understand. He thought the money was going to charity. He was basically blind.
Yeah.
And he thought it was going to charity,
Wow.
but the way that this was drafted is that a large part of it was going to him and some of it was going to charity.
Wow.
And he was pushing to get this document signed real quick,
Yeah.
which made her uncomfortable, the advisor, and that's why she dug further into it.
Yeah, that's a very quick way to lose your law license.
I would hope.
When you do that. Now, we can, as attorneys, we can act as a trustee for
Yeah.
an individual, but we cannot also be a named beneficiary.
Right.
If I'm creating, even if I'm creating a trust I'm not the trustee of,
Yeah.
I can't create a trust for someone but name myself a beneficiary,
Yep.
except in very certain circumstances, okay? If I'm doing my mother and father's
Right.
trust, for example.
Okay.
But no, if I just have a general client come in and ask me to prepare their estate plan and I name myself the trustee and a beneficiary, I've gone outside of what I'm legally allowed to do.
Okay.
But again, you have to get caught.
Yeah.
Yeah.
All right, so here's one. Now, this is, so first of all, when you draft a trust, how many pages is it?
Oh gosh, roughly 30 to 35, we'll say, give or
Okay.
take.
So this one, I'm going to read you some excerpts from it.
Yeah.
A 95-page document,
Okay.
which, I've seen them bigger. I've seen them
Sure,
less,
that's I call it a kitchen sink trust.
There you go.
And a lot of times it's way overboard and it's doing things it does not need to do.
And in this case, shouldn't do.
Okay.
Well, let's see what
Possibly.
you-
Yeah, we'll see. Yeah.
So, but that is one of the issues, I think, with a legal document is the language doesn't make sense to a lot of people.
Yeah.
And if the document's too thick, they just don't read it.
Yeah.
So, this one, the attorney is set up as the trustee
Okay.
all the way through. So I found this interesting. I don't normally see this. There was a one single page acknowledgement letter signed by the attorney
Okay.
and the client. And then there's all the trust document.
Okay.
And in that one page acknowledgement, it made very clear, and this is what it wrote verbatim, I've appointed XYZ Esquire, so it's the name of of this particular lawyer, as personal representative, agent under my durable power of attorney, successor family trustee and successor independent trustee, and such trustee can only be removed if such removal constitutes a for-cause removal for purposes hereunder. For cause removal shall mean the intentional or grossly negligent disregard of the trustee duties hereunder, or an act or an omission by the trustee of a material nature which is unlawful, immoral, dishonest, or unethical. At our meetings, I have discussed with XYZ Esquire other options that I have available for these appointments, including banks, trust companies, etc. I understand XYZ Esquire will charge hourly for the services in this regard. And then at the bottom of this understanding letter, they both sign. And I don't normally see that accompanying a trust.
Yeah. There's a couple things to unpack here. One, this all-encompassing letter acknowledging that this individual is wearing 3 different hats.
Right.
Personal representative, trustee, power of attorney. That acknowledgement is not going to trump what the actual documents say.
Right.
So if the durable power of attorney has that individual appointed as the primary, that's what controlled.
Yep.
If it's someone different than that individual, the power of attorney controls, not the acknowledgement.
Right.
So if in fact this individual was designated the power of attorney, was designated as the personal representative, was designated as a successor trustee in those individual documents, that may have just been to kind of bolster that there were no shenanigans going on. We have this letter to support why we did it. Now, the other thing that's interesting about that letter is it is defining certain things that need to take place for the individual to be removed. But again, we have statutory law that describes the things that can get you removed.
Right.
So that's all fine and dandy to put in this acknowledgement letter, but the Uniform Trust Code tells us what the trustee can and cannot do. And if they have breached those fiduciary obligations,
Yep.
it may not have been within this list, but it certainly gives cause to a beneficiary to say the trustee breached.
In
their
this case, the beneficiaries are not family, doesn't have any children, and they have no idea that they're even the beneficiaries.
This
These
is where I
these particular
often
people.
see attorneys or others name themselves as trustees, as fiduciaries, because there is really no one to keep an eye on them.
Yeah.
They are billing an obscene amount of hours
Yeah.
for something that may take 20. They have billed 70 at $400 an hour.
Yeah.
But the charity that this money, or charities this money is going
It's
to,
just individuals.
they're,
People.
or friends, they're
Yeah.
just happy they're getting a check.
Yeah.
They're not assuming the individual has done anything wrong,
Right.
so they kind of fly under the radar and can excessive bill. Yeah.
To me, in this one page, and so if first of all, the beneficiary would be like flabbergasted that they're receiving any money at all,
And that's why
Not
they
ex-
usually
not
look
expecting
past
it.
what the trustee's
If
doing.
they ever did question it,
Yeah.
you can show this one single page letter and say, listen, this is exactly what my client wanted me to do. And it covers the basics. It says you're in control of everything. You can get paid and you can't be contested, basically. That's the 3 things that a beneficiary would take out of it.
Yeah. And again, that's fine and dandy that that's what this acknowledgement letter says,
Right.
but that's not the law.
To me, this was just a summary, because all that's in the document too. But this is like a nice, concise summary.
Yeah.
If they ever had to show it to somebody
Right.
to support it.
Is it reasonable compensation for an attorney to charge 3 hours at $400 an hour to go to Chase and deposit a bank? I don't think it is.
Yeah, hopefully.
And
they've
I
got
think
it.
a beneficiary would argue it isn't as well. So we have this gray area of what's reasonable and what isn't.
Yeah.
And when have you crossed that line? And that's what a court will
Right.
determine. Yeah.
So, next thing, if XYZ Esquire is unable to act as family trustee, then the managing partner of XYZ law firm shall select a partner at XYZ Law
Yeah.
Group.
That's exactly what I would have expected
Right.
that to say. Yeah.
Right.
Yeah. Again, if the document itself states that, then it's okay to do that.
Right.
But again, you get into the situation where you have individuals that are acting on behalf of an administration and not necessarily doing the wrong thing, but maybe they're not doing the right thing and no one is any wiser
They
for
could
it.
be doing the right thing. In this case, I'm familiar with this firm. I've seen them over the years, and I know that I would not trust this document.
Yeah.
I wouldn't trust the intent of the document. So here's what they wrote in the no contest clause. It is a grantor's strongest intent that the estate be settled as promptly as possible and without controversy over the distribution of the grantor has made in the trust. Therefore, if any beneficiary under the trust contests any provision of the trust, directly or indirectly, the grantor then revokes the gift the grantor has made to that beneficiary and direct that gift that the beneficiary would have received be distributed as if the beneficiary had predeceased the grantor.
Yes.
Now, it's pretty common to put some no contest clauses in a trust.
That
So
is
maybe-
that is completely normal.
Right.
But what that isn't touching base on is I may contest what this individual did, and yes, the no contest clause has basically said now I get nothing
Right.
because of doing it. However, if I'm successful in court because I took you, the trustee, to court, that
Right.
you breached your fiduciary obligation, that no contest clause is no, I have been successful, you have been removed,
Yeah.
I will get my gift.
You have to be successful.
I think you have to be successful.
So it's pretty tough.
I think if you are unsuccessful, then you're stuck.
Is it always that direct?
Very, very direct.
Why is that? Why do that?
You know, I like to explain that one of the reasons people do trusts is for anonymity, to keep their affairs private. If a beneficiary is not happy with what they get, so they now create a legal issue about this and now make it a public issue and require all sorts of legal fees, the consequence in doing that is you will get nothing if you are unsuccessful in your contesting. Yeah.
I mean, it makes it difficult to challenge, but how you're being treated, I guess. But you better be. But you can demand the accounting. You can do your homework,
Correct.
and your homework should be able to identify for you
And
whether
support
or not,
whether you're going to go forward with this.
whether or not you're
Correct.
being misrepresented.
Correct. Now, where I really see this important is when people have, husband and wife have 3 children and they are treating one differently than the other.
Okay.
Maybe they have been estranged from the family for a decade. They don't
Okay.
want to completely cut them out of the loop, but they're giving their 2 kids 40% of the net proceeds each. And
Okay.
this one child they have 0 relationship with,
Yeah.
they're giving 20% to.
Okay.
I like to bring up the no contest clause in a situation like that and say you realize your child you're giving 20% to is likely going to contest this. But as long as your trustees have done their job, just
Okay.
because they were treated differently in and of itself isn't going to make them successful. They would have to make an argument that you were under duress, you didn't understand what you were doing when you signed these documents to be successful. But the no contest clause is perfect for something like that because
So-
we don't want that estranged child making a problem.
Is the intent of the no contest clause to protect the distribution wishes of the grantor,
Yes.
the parent, or whatever?
I would say that's the main
more
reason.
than it is to have a somewhat questionable trustee be able to get away with it.
I would say it's to protect the distribution pattern. And if
Okay.
a beneficiary isn't happy with what they get, too bad.
I got it.
Yeah.
Okay.
Yeah.
Couple other things. Distribution of principal. The trustees are authorized and empowered, acting in their sole discretion, on how to handle the distribution of principal. Distribution of a share for all beneficiaries, commencing, and I just add that in there because there's more that show the power that this attorney gave themselves. Commencing with the date of the grantor's death. And here's one thing I do when I'm reading a trust. You've got trustee, successor trustee, grantor, you've got names in there.
Mm-hmm.
And it may not be confusing because you draft them and you've seen so many, but every single time I read a trust, I will say, commencing with the date of dad's death, you know,
Instead of using the word
right,
grantor,
Paul, as trustee, is authorized and empowered to.
Yeah.
I got to throw the names in there.
Okay.
To have it make more
Okay,
sense to me.
okay.
And I tell clients when you're reading your own trust, throw your names in there. I know it says grantor and all that stuff. Throw your name in there,
Sure.
and then you can follow the flow a lot
Sure.
better.
Sure.
But anyways, commencing with the date of the grantor. So the grantor is the person that drafted the estate document.
They
and has
created
passed away.
it. They
It's
wanted
usually
to.
mom or dad.
Yep.
The trustee shall pay to or apply for the benefit of the grantor's beneficiary during the grantor's beneficiary's lifetime all the net income from the trust estate in convenient installments, in addition to interest and sole discretion to apply principal. All retirement benefits to be paid into a conduit trust shall set up separate trusts and distribute only the required minimum distribution, which the law currently is, and if the grantor hasn't reached the age of RMD, there is no RMD.
Right.
They can hang on to it for 10 years and then distribute
Yeah.
it. So there's multiple paragraphs that were describing how money would be distributed. And the way that this trust was drafted,
Yeah.
only income needed to get distributed. Only the RMD from the retirement accounts needs to be distributed. Principal does not have to be distributed. And they will only receive this over the course of their lifetime. This is, what do you call this? One of these trusts that go on forever?
Correct.
What is it called?
I just say they go on in perpetuity.
Yeah, there we go.
Yep,
Yeah.
yeah. So,
So this trustee, the
yeah.
estate attorney, has drafted a trust that goes on forever
yeah,
and has put them as the trustee, has put their law firm as a successor trustee. It's one hell of an asset they've created for them, for their
it
business.
sounds like this is language from an irrevocable trust.
Well, it's drafted as a revocable
It was
trust.
shocking.
Yep.
Yeah, yeah. So listen, we have spendthrift provisions all the time in trusts, okay? And I will prepare trusts for.
Now, why don't you explain why you're saying that, though? It sounds like it came from an irrevocable trust.
Yeah, well, because it's using very specific language about the trustee's sole discretion.
Right.
It doesn't really even sound like the beneficiaries can compel the trustee to make a distribution for their health,
Right.
their education, or their support.
Right.
That is language that I would typically see in an irrevocable trust,
Right.
not in a revocable trust.
Right.
Generally, we will see language for young kids if we don't want them to get their money right away. There are spendthrift provisions that say it can be distributed for their health, their education, their maintenance, their support over this certain period of time. Occasionally, I will draft a trust with a lifetime distribution to it, but it's very rare circumstances where maybe the spouse has been diagnosed with something. And if they pass away, if the one passes away and the other one gets an inheritance, they can't even really manage it on their own anyway.
Right.
And why would we give them a lump sum? So have somebody act as trustee for them over their remainder of their life, and then whatever is remaining in it goes to these residuary beneficiaries. So
Okay.
we do these things, but this language is very restrictive on what the trustee has to do,
Right.
which is basically nothing.
Correct.
And what's also interesting is the language regarding how the qualified assets are treated could be at odds with the Secure Act 2.0, which is just so. When it comes to qualified assets and certainly conduit trusts, the Secure Act controls
Right.
what to do with those qualified assets. If you have provisions in a trust that contradict that, You could run the risk of the financial institute saying, okay, fine, this is
Got
no longer,
distributed.
we're just going to make this a lump sum distribution
But
because of the being at odds with
Even
the,
if it is a lump sum distribution, it does go into that conduit trust then, which is controlled by the trustee, right?
Correct.
Yeah.
Correct. If it
Because
was a
the
lifetime trust,
Because
yeah.
if the trust is the beneficiary.
If the trust is the beneficiary, and
Right.
then at the distributions are getting made at the trust tax rate.
Right.
So now you've made the government a beneficiary.
Yeah. And then in the retirement accounts, it says the trustee shall treat the inventory value of the trust's interest in the retirement benefit as principal and allocate any subsequent increases in value or charge decrease in value in such interest to income or principal with a reasonable method selected by the trustee. And when I'm reading through this, and there's like 2 pages of this in there, it seemed like it was trying to define how to determine what comes out of the IRA as income or principal. So in other words, like if let's say $100,000 comes out of an IRA in the IRS, that is income.
Yep.
Right? But the document, and then it's going to go into a conduit account, conduit trust. In the document, in what I was reading, if I was reading it correctly, is trying to define, is that treated as income under the purposes of income as defined by the trust?
Yeah.
And therefore, does $100,000 sit in this conduit account
Yeah.
and not all have to be distributed because it's all technically not income as defined by the trust?
Yeah.
And therefore, a portion of it can sit in this trust
Yeah.
as principal, and a portion of it would need to be distributed as income.
And again, I would say, what does the Secure Act require?
Okay.
And B, the other thing I think this really gets to is this is an accounting issue.
Right.
And this is where I would rely heavily on a CPA as to, are we doing the right thing considering this income, passing it through this way? Are we doing the most tax beneficial thing we can?
Yeah.
Versus the language just saying we do this.
But in this case, the beneficiaries, in this particular case, because I think this is very clearly an ill intended document,
Yeah.
the beneficiaries wouldn't even know how to challenge this.
Correct.
Would feel like they can't challenge it.
Correct.
And so when it comes to income, generally speaking, so there's this, which I think is a bad trust, but even in a well-drafted trust, there's often this discussion about income versus principal. And so if you invest money into a brokerage account, investment account, you
Yeah.
could hold stocks, you could hold bonds, you can hold mutual funds, ETFs, a variety of different financial instruments. And some of those instruments pay yield. Some of those instruments pay a dividend. Some of those instruments don't. They just may appreciate or depreciate in value
Yeah.
as the year goes by. So income is typically considered a distribution from a particular investment. So in other words, if you have a stock that pays a dividend,
Yeah.
think of one, Microsoft, they pay a dividend, I think.
Yep.
So versus a stock that doesn't pay a dividend, who might that be right now? Let's say like Uber probably doesn't. I don't
Sure.
know. I shouldn't
Yeah.
say that
Yeah.
without looking up. But so if Microsoft paid a dividend, that income would then be distributed to
Correct.
the beneficiary.
Correct.
But Uber may not ever,
Correct.
distribute income, and therefore they might not ever have the right
That's correct.
to take anything.
To take income, but they can always take the reasonable and necessary distribution
Normally.
for their benefit.
Normally.
Correct.
In this particular trust, I
It
think
seems like they're
trying to
making it very
protect
difficult.
that, yeah.
Correct.
So when you're investing money,
Yeah.
if you're limited to the income, then let's say a trust can only distribute income,
Yeah.
then you might invest that differently than
Absolutely.
how, if that was owned outright, you would invest it. Because if you are not allowed to take principal out, then you need things that generate income and not necessarily grow.
Correct. Correct.
If you're allowed to take out income or principal,
Right.
you can invest it any way you want to,
Correct.
income and growth,
Yeah.
and take out a distribution that is reasonable.
Yeah. Yeah. No, I agree. And this is where I say working hand in hand with a financial advisor is so important. Because if that is how a grantor wants to structure their trust, they don't want to limit the beneficiary's ability for income. But if they don't have the right investment, that's what they have done without knowing it.
Right.
Which is why attorneys should stay in their lane and
Right.
financial advisors serve their purpose. And this is where we'd want the grantor to sit with you and say, I want to limit this distribution to only income,
Right.
but if it's only the Uber dividend, they're going to get nothing. So what is a better financial mechanism that we can use so there is actually some income created?
Yep.
So that's more of a financial issue
Yeah.
than it is a drafting from an attorney's perspective issue.
I met with a lady a decade ago, probably 15 years ago. I don't remember her name. We'll call her Virginia. She was in her 80s. Husband had passed away a long time ago. This is a relationship where it's not as common today as it was maybe 20 years ago, but where the husband did all the finances and she hadn't. He passed away. He had set up their estate, to go through a corporate trustee rather than have her be able to oversee the money. And so this had been going on for like 15 years. So Virginia is receiving literally like 25 grand a year. This thing's worth like $2 million.
Yeah.
Because it was all invested for growth.
Yeah.
And so she's only receiving 25 grand a year. All the corporate trustee and all the fees and everything was over $60,000 a year.
Yeah. Yeah. Yeah, which is why we try to not have corporate trustees act as trustees, because they will typically just take a set percentage regardless.
They should have been distributing
of the
some principal to her.
Yeah.
They could have. I read her trust and it allowed for principal,
Yeah.
but they weren't distributing it. They're just giving her income.
Right.
But here's the weird thing. I don't get this, but it gave her plenty of authority to fire the trustee and even appoint her daughter.
So she had a power of appointment in
Yeah.
there. Yeah. And she chose not to exercise it.
When I explained this to her, she thought I was acting crooked.
Sure.
She had been under this rule
Yeah.
for like 15 years, and she thought I was the one that was trying to trick her.
Yeah. Yeah, I just met with someone and wasn't even a client, just was talking to a fellow friend. And they were in a similar situation where significant other passed, left them a nice size amount of money, but they put a restriction on there that their distribution is limited to $2,000 a month. And that's what they thought.
Yeah.
But then I reviewed the trust for this person and said, but wait, there is also the ability for you to reach out to the trustee and request additional distributions, because there is provision there for health, education. Maybe you need a new roof for the home, right? Things like that. Sure. A big bill for a medical bill. Ask for distributions for those things, but they were almost afraid to do it. I don't know. And when I had this conversation with that individual, I had to convince them to stop acting like you don't get anything more than this $2,000. There is the ability there for additional distributions. You should be asking for them. And the worst thing that can happen is the trustee says, no, I don't believe it comports with what the trust intention is, so I'm not going to distribute the money for X, Y, and Z. But unless you're asking for it, they're not going to do it. And again, kind of to your point, I don't know why some beneficiaries just kind of feel locked in and will not request anything more than what they're given, even if there is the ability to receive more.
So I mean, 40, 50, 60, 70, 80-year-old adult children acting as if they're under this heavy hand of a parent figure that's going to tell them no.
Right, from the grave.
Yeah.
Because they're deceased, and now a trustee is the one controlling this money that they inherited.
There was a few years ago, I was meeting with somebody, and again, she had a corporate trustee, and the corporate trustee, the investment managers, or corporate trustee and an investment manager overseen by that corporate trustee. And the investment manager made them feel inferior. They said we normally don't deal with accounts this small.
Yes.
It's over $500,000. It sounds like that's a pretty decent amount of money.
Yeah.
But anyways, made them feel inferior. We don't normally deal with accounts this small. Made them feel like a huge burden. Wouldn't really interested in taking their calls or hearing their input on how to manage the money. And when I read the document, they had the trustee, number one, had the full ability to get out. And under some, like, you could read this document and you could say, yeah, I think they met the threshold to be able to have a full distribution. Or you could make the argument that the trustee could hang on to it for another year. But either way, however you wanted to read the language, you could make either argument.
Sure.
So this corporate trustee or the investment manager had no reason to have to manage the money if it was such a burden. They could have given it up, no problem whatsoever. They made them feel inferior, but they wouldn't give up the reins to the money.
I'm shocked they even agreed to act at $500,000. My experience with individuals who have named corporate trustees is that it never works out well. And often what we see happening is once the individuals pass away, the corporate trustee, like you just said, says, this is not enough money. There is nothing in it for us. We will just decline to act.
Oh, really?
And this is a free country. You can't force somebody to act as a trustee. And they will decline to act. And now it's either going to be who the alternate is. In some cases, for example, in my trust, we have a provision that says if there is no longer a named trustee, the majority of adult beneficiaries can appoint a trustee. So there's usually an out there. But I often see corporate trustees, when it comes down to it, just decline to act. In this case, it seemed like they were declining to act, but not declining to act.
I think it's like
because they were
play.
charging the 2%. What maybe 1 to 2%. The max they can off of this $500,000 investment for doing nothing.
Literally.
Yeah, in perpetuity in their head.
And making a power play on it.
Correct.
Yeah.
Correct. Yeah. Yeah.
And why do people feel like they can't challenge it? And she had all the authority to challenge it, and she didn't want to do it.
Yeah. You know, I think that certain professions, certain types of investment managers can impose their will on people who may not be educated enough to understand they have some recourse, and they automatically feel lesser. They don't want to. I don't want to. James knows what he's doing. Why am I going to contest that?
Right.
And they kind of have this hands-off approach as if these people are the know-all, be-all, but they are not. And so they're taken advantage of. They really are. They're taken advantage of.
All right, I got a couple more that were in this one document. Let's see. This was interesting. It said resignation trustee. Any trustee may resign to another trustee which names the same, but they name the same firm as the other trustee. The family trustee can remove the independent trustee only for cause removal.
Yeah.
However, the family trustee is the same law firm.
Right.
So they gave a method within it.
Yeah.
For removal, but
just appoint someone else in the same
It was
building.
themselves to do the removing.
Correct.
So normally, I love it when there's methods to remove.
Yeah.
And here, it's the same farm. Obviously, it's never going to happen. But I think ultimately, whoever we're giving our money to at the end of the day, we got to trust them to some degree. Yeah. They may be young right now or whatever, but at the end of the day, they're getting our money. At some point, I'd rather trust them over an unknown.
Correct.
And ultimately, I personally like to see trust documents that even if the beneficiary is too young at the moment and there's a trustee overseeing or whatever, that they have the ability to have themselves appointed if they're of age or appoint somebody.
Yeah, so you raise a good point. What I would like to typically do is put that sort of age distinction in there.
Yeah.
So-and-so shall act as successor trustee until John so-and-so, the beneficiary reaches the age 35.
Right.
At that time, they shall act as successor trustee. So there's a trigger in there to get somebody else in that role. There's always, again, the ability to remove a trustee through the court proceeding because they have breached their fiduciary obligations, but that requires the beneficiary to be somewhat sophisticated
Yep,
to even know that they've breached. What the recourt, hire an attorney, we are going to petition the court to remove the right. To understand what that process is requires some sophistication, and a lot of beneficiaries don't have it and don't know they have the ability to do so.
Right.
Yeah.
Yeah. Let's see. Trustee of each trust shall incur only costs that are reasonable in amount and appropriate to the investment responsibilities of the trusteeship. Grantor specifically recognizes that if my attorney or my attorney's law firm is employed as trustee, then hourly rate of such person shall be considered reasonable. That's what you were saying earlier.
Yeah.
You
So
know, is it
$400
hourly rate
an hour
good
to-
for mailing a letter?
There you go. There you go.
Yeah.
And I assume that this language was drafted by the attorney, not the grantor.
By the attorney,
Yeah,
and it's in the
absolutely.
trust.
Yeah,
So,
yeah.
like I said, they put it in the upfront letter, but then they reinforced it throughout the
Absolutely.
document.
Absolutely.
That
Yeah.
upfront letter was just kind
Yeah.
of a summary.
What they did is not illegal.
No trustee shall at any time be held liable for any action taken or not taken. Investment advisor, the family trustee of the trust shall have the rights to appoint and remove at any time the investment advisor to the trustee of such trust. Again, that's fine language too.
Yeah.
But in this particular case,
You're removing the investment manager just to hand it over to the trustee.
yeah.
Is what it sounded like.
Yeah, you can do whatever you want.
S-
And
it-
so even if a separate investment manager, so maybe the law firm employs an investment manager.
Maybe.
You know,
Often
or-
that's what when I see documents where attorneys have drafted themselves as trustees, it is not unusual to also see language in there that requires the trustee to use a certain financial advisor. And that automatically screams as not kosher.
I agree.
Yeah,
I've
when
been
I
in
see
this
that.
business a long time now, over 20 years, and so I've worked with and met with a lot of different estate attorneys over the
Yeah.
years, and I've had some of them, you know, they'd like a referral relationship, you
Sure.
know, and I had some of them where they'd put my name in a trust document, and they would word it, you know, the beneficiary is to use James Studinger or
Mm-hmm. Sure.
whatever, and I'd tell them take it out.
Yeah.
I said you can reference me as a point of contact if you'd like to, but
Correct.
take it out.
Yeah, I have a spot for the grantors to put that information. I work with
Yeah.
James Studinger. Here's his number. How you get in touch
That's
with
hugely valuable.
him? But
Number to
I'm
call.
not right. But I'm not going
Yeah.
to put you in
Lock-
the document
Yeah.
because then it looks like our relationship isn't on the level anymore.
Right.
Now it looks like you're referring me work for no other
Right.
reason to make sure that you continue to manage these assets when these people die.
Yeah. I don't know. This one, I unfortunately I've seen too many times, and it is one hell of a business model.
Yeah.
That the original people, the grantor, they've passed. This goes on forever.
Yep.
The distributing income, when they go to sell their business, they have this on the books, this reoccurring revenue stream. I mean, it's hugely profitable.
And when we typically see this, the grantors, most of the time, my experience is, don't have family. They do not have blood heirs. So this is all taking place, and like you said, this long lost cousin just got a check. They're just happy that they were remembered by
Right.
Uncle so and so they haven't seen in 40 years.
Right.
So everything that's going on behind the scenes is not questioned by anyone because the beneficiaries are just thankful they're getting
Yeah.
something when they
Surprised.
expected
Yeah.
nothing.
They're
So
surprised in the
this
first place.
is where we see this sort of language most.
Yep.
I would be shocked if this was done in a trust where the children were also the beneficiaries,
Right.
because they are more inclined to say, whoa,
Yeah.
what did you guys do to talk my parents into doing this?
Yeah.
And this reeks all the way through.
It's incredible how easily people, intelligent people, informed people, whatever, can be talked into almost anything.
Yeah. When people meet with their financial advisor, when they
Yeah.
meet with their attorney, there's almost just, they assume that who they're meeting with is doing everything the right way.
Yeah.
As if they have no flaws
Yep.
and would never do anything they're not supposed to do, but that's not the case.
Yep.
Yeah.
What's a trust protector?
I don't really know what a trust protector
Okay,
is.
so that's
Yeah.
language I see in some
Yeah,
trusts.
yeah.
It's meant. I've never really understood it because it's in the language. It's meant
It's
to
in
kind
the
of
language, and I haven't put one in
to
a
be
long time.
to police the trustee. But then a lot of the times the trust protector is the trustee. So
I haven't put them in
Okay.
a long time, so it's a question that I don't have readily at my
Yeah.
fingertips. But
maybe it's not even. I've seen it
it's used.
sometimes,
It's still
and sometimes
used.
I don't.
Yeah. I'm not typically dealing with clients who are using corporate trustees and
Okay.
it's usually family.
Okay.
And so trust protectors don't really get into what I'm dealing with
Okay.
often.
When
Yeah.
I've seen it, how it's been described is that it gives somebody some kind of authority to be the watchdog.
Yeah.
Yeah.
And again, I don't really know what that means.
Yeah.
And when I say I don't know what that means, it's more of what can they do?
Yeah.
And does their authority supersede the trustee?
Yep.
Do they just give instruction to the trustee? Are they allowed to stop the trustee from doing things? So when I say I don't really know what that is, it's not that I don't know what that is. It's I don't really know where their authority lies.
Yeah.
And what they can and can't do as the protector.
Okay.
What that sort of allows them to do on behalf of the trust.
All right. So I'm going to ask you about another one I've been seeing a bit
Okay.
often in the area.
Yeah.
Yeah, all over, actually. I call it the $10,000
Yeah.
estate plan. And I don't know why they're always 10 grand.
Yeah.
I don't get it.
Yeah.
So this one, more recent one, they're seminar driven usually, educational workshops.
Yeah.
And people go and they get afraid about
They
how
scare
they're
you
gonna-
to death that you're going to lose every single thing you've ever worked for.
all your money before you go into the nursing home.
Correct.
And you might be 40 or 50 years old and you're still worried about it.
Correct.
And you don't even have that much money yet.
Correct.
So I looked up on this one particular person because this was pretty recent. So he's got a book published. The publishing company is an advertising company. So most people, they're not going to do a whole lot of legwork on this thing. So you look up the seminar, who sponsors the seminar and the content of the seminar. And it's a marketing company and it's a nonprofit. And it looks like we just want to educate the general public because people don't know enough to do with their money and blah, blah, blah. It sounds great. When you go to their website and look at their website, they're marketing to financial planners, estate attorneys, whatever. It's a sales machine.
Yes.
And all over the websites, all the language is about how much more revenue we can help you realize, and this is our process, and blah, blah, blah.
Right.
So in this case with this particular book, in the advertising company's website, it says, to become the go-to expert in their field, you need a high-impact online presence that will help you make the impact you want deserve. Get a customized roadmap to up-level your thought leader status with an authority blueprint designed for top leaders who understand the market power of strengthening their thought leadership through a strategic digital presence. And then authority resources. Build your authority through podcasts, ebooks, videos, branding, public relations, thought leadership, marketing, solutions through social media strategy, book publishing, content writing, brand strategy, ad campaigns. Grow and elevate your personal brand, influence, exert influence through thought leadership, lead, stand in a category of one. We're building leaders of authority. In the world of thought leadership, authority is not a luxury, it's a necessity. On and on and on.
Yeah.
So this is the machine putting this particular $10,000 estate attorney.
And what you just read has nothing to do with estate planning. That is somebody that you would meet with if you're trying to start and grow a business.
Right.
How do I get my business? How do I scale? That can apply to anybody.
It can
so
apply to
I
anything
don't
and
know
everything.
what this has to do with estate planning and in the $10,000 plan, other than they're just marketing everything they can possibly throw at you to make it look enticing.
And make you look like you know what you're talking about.
Correct.
Yeah.
Yeah.
Put some legitimacy behind it.
I guess if that's what you would consider it. Legitimacy, I don't know. Just buying into something because they say it comes with a qualification doesn't, I don't think, give you
So this
legitimacy.
particular plan, because it has caught a number of people where they think they need it.
Yep.
Where I have seen it, that people adopt it, they're in their 50s, sometimes older, but a lot of times I've seen them in their 50s. They've got a decent amount of money, but they are not financially independent yet.
Okay.
They're not ready to retire. And sometimes they have some money but not cash flow. So sometimes they have other problems, short-term problems that are more immediate than that. They might have kids that are still in college.
Yeah.
They might be hemorrhaging money, basically, taking care of today. But they go into these things and they get convinced that by the time they do accumulate their money, they're going to lose all of it.
If they haven't protected it.
If they haven't protected it, the kids won't get anything. Their remaining spouse won't have anything.
Right.
They're going to be broke, and all of the savings they've done their entire careers for nothing.
Yeah.
So can you explain what is this unbelievable document that's supposed to solve all these problems, and what's wrong with it?
So what you're talking about when we get into this sort of discussion is really like asset protection trusts.
Okay.
I think is where you're going with this. Now, there is a place for irrevocable trusts.
Right.
When you have your spouse who is in a nursing home already.
Right.
And you are bleeding money.
Right.
Or you have been diagnosed with dementia. It runs in your family. It is inevitable in the next 2 years. You will be in a nursing home.
Right.
Then that is a perfect example of you need to do some Medicaid planning.
Right.
To try to preserve what you can so it doesn't go all to the nursing home, okay?
Yep.
But that's not what this is marketing to.
Right.
This is marketing to, hey, everybody, you can lose your money if you don't do this now.
Right.
Regardless of your income, regardless of your health, regardless of your age, regardless of all of those things, this is what we need to do.
Right.
There are situations where things like asset protection trusts are beneficial. But asset protection trusts versus someone who's getting ready to qualify for Medicaid are different things. Okay? If you are trying to deal with an estate tax reduction, which is so high most people aren't worrying about that anymore, or being able to qualify for Medicaid, you're doing a kind of a traditional irrevocable trust. Now, an asset protection trust is a type of irrevocable trust, but it is typically not used for Medicaid and planning and estate tax reduction planning. An asset protection trust is typically created for the purpose of stopping creditors from getting at an asset.
Okay.
Okay? If you are a surgeon and you make a lot of money, you have a lot of money, your type of surgery you do comes with great risk.
Okay.
So malpractice is a big concern for you.
Okay.
You are concerned that if something goes wrong, your insurance, your umbrella, your everything is not going to cover when you get sued, then an asset protection trust for somebody like that makes sense.
And would you do that on a portion of money, or what would you do?
You do that on an asset.
Okay.
Maybe they had $2 million in a brokerage account.
Okay.
Because once that asset gets put into this protection trust, it cannot be taken out.
This is the little thing that people don't always understand.
Yeah, and so to kind of go into the So there's a couple of reasons why you do an irrevocable trust, why an asset protection trust may work. So there are needs for those
Right.
sorts of things. But marketing to the general person to do this, I'm not going to say it's disingenuous, but I don't think that the individuals have a grasp of what they're really getting and what they may be doing.
Right.
A, you don't have the money to get rid of assets.
Right. You still need to
Okay?
accumulate.
You are going to need them.
Right.
In an asset protection trust, you may be able to claw that asset back, but now you've ruined the protection of the trust. Okay?
Okay.
So now that asset is subject to creditors.
Okay.
Okay? In a lot of asset protection trusts, they are self-serving, meaning the grantor has the ability for discretionary distributions.
Okay.
Well, if that ability exists, Medicaid looks at this stuff in that trust as income.
Okay.
So you're not, again, helping a Medicaid issue.
Okay.
Okay. The other thing that I see a lot with these trusts is, again, people think they're getting ready for Medicaid and nursing, and that's not what they're doing. It
Okay.
isn't for Medicaid purposes typically. It is usually to just protect creditors from getting at something. So the language in a traditional irrevocable trust and an asset protection trust are different. Okay, in an asset protection trust, you cannot compel, the grantor cannot compel the trustee to make distributions. Okay, help educate, you cannot
Okay.
compel them to do so. If they are just kind of using it as a sham, and you just appointed your next door neighbor as a trustee and he's giving you distributions for whatever you want, you're going to lose your protection. If you're taking
Right.
assets out of it, you're going to lose your protection. What people fail to understand in general about I'm going to lose everything if I go into a nursing home, my family will get nothing, is there is the preparing for that situation, and then there is the practical application of that. So when we see attorneys preparing certain types of trusts so people can be Medicaid eligible, one of the things that people don't understand is I hope you kept 2 years of income out of that trust. Why? Because if you're trying to go to any sort of a nice facility, you are going to pay out of pocket.
Okay.
They are not going to take you as a Medicaid patient. That's just the reality of it. Okay? So when I hear people say, well, I'm already Medicaid eligible if I do X, Y, and Z.
Yeah.
Well, if you go into a nursing home, you're not going to like the nursing home you're stuck going to.
Yeah.
You need to be paying these $7,000, $8,000, $9,000, $10,000 a month for a year, 2 years. And then you can go broke, and then you can stay in that facility because it's a Medicaid bed at that point. But they're not just taking anyone off the street who has Medicaid. So there's a lot of planning that goes into this where people think they're getting a benefit, which, again, they're typically not, because it's really to protect creditors, not to get you Medicaid eligible, that they're not understanding the real financial consequences of giving your money away and not being able to give it back. And if you get it back, you ruin the protection of the trust anyway. And they're not understanding how nursing homes work. And when you get in and how you stay in, and trying to go into a nice facility when you're already broke is never going to happen.
So it's unbelievably complicated to do the qualifying part at the point of when you need care. And why draft a document to handle a very complicated situation which may change by law who knows how many times over the next 20 or 30 years.
Correct. Correct.
Yeah.
It doesn't
Why
make
do
sense.
that?
It doesn't
Deal with it closer to the point of reality.
Correct.
And then try to go make as much money as you can and
Correct.
save your money and accumulate your wealth and and enjoy it.
Yes.
Yeah.
Yes.
Yeah. So let me ask you then, we talked about where there's some problems, some of the wrong trusts and stuff like that. Bottom line is what a normal, for most people, what should they think about with their estate plan? They've heard of wills. People hear of trusts. They maybe have a trust, maybe don't have a trust. Power of attorney, patient advocate. Like, what is a normal thing for people to do when they think about their estate plan?
So again, everyone's situation is different. There are blended families. There are children with special needs, right? So to kind of take away some of the nuance, your traditional husband-wife 3 children.
Right.
Maybe they're minors, maybe they're adults.
Okay.
Okay, and there are benefits to doing a trust even when they're adults.
Yep.
Okay. That is kind of your traditional full estate plan.
Yep.
Where, like you had said, we're doing that durable power of attorney, healthcare power of attorney, HIPAA release, the advanced directive, the lifetime side of things.
Yep.
Then from a post-death perspective, we're doing your joint revocable trust. We're doing your pour-over wills, and
Yep.
we're deeding your home, and we're maybe dealing with a deed
Yep.
for your cottage.
So
Okay, that's the kind of the norm.
So the things that help you while you're alive, power of attorney, because
Yep.
that gives instructions for who can act on your behalf if you're unable to, right?
Correct.
Patient advocate, right? You
Yeah.
said?
Healthcare power of attorney. Yep.
Healthcare
Appointing a
power of
patient
attorney.
advocate. Yeah.
Because that says this is who I trust to make
Correct.
medical decisions for me if I'm unable
Correct.
to.
Correct.
Yeah.
So
And what was the other life one?
a HIPAA release, which
HIPAA
is just kind of
release.
part B of that
Okay.
healthcare power of attorney.
Yep.
But I think to kind of dive a little deeper into those documents, there are several misconceptions people have, and they don't think they need
Those two documents.
the healthcare power of attorney, durable power of attorney, HIPAA. They don't think they need them. And one example would be, well, I'm married.
Right.
Of course I can make medical decisions for my spouse if they're in the hospital.
Yep.
That is absolutely not the law. That is not
Yeah.
the case.
Yep.
Now, the caveat to that being is we don't often see hospitals enforce something like that. In blended families, that certainly is the case. They are not
Okay.
going to take the word over new spouse over biological adult children.
Yeah.
Right? And so if you don't have a healthcare power of attorney in place, appointing a patient advocate, there is a chance that your loved ones will not have the legal authority to make medical decisions for you, and then they are going to go through a guardianship process in probate court,
Yeah.
which is far more expensive and more of a nuisance than if they just had the power of attorney in
And
place.
who knows what kind of condition you're in while they're
Correct.
doing all that.
And then on the financial side, again,
Well, let's go back to that medical for a second, though, because this is something that catches a lot of people by surprise.
Yeah.
You're a parent. You're used to being a parent to minor kids. Anytime they break an arm, get a cold,
Yep.
whatever, you take them to the hospital.
deal with it, yeah.
And the doctors talk to you as much as they talk to them, and you make decisions about how to take care of them.
Correct.
And then, bam, they're 18, they go to college.
Yep.
And you still think you're a parent.
That ship has sailed.
Yeah.
I can give you example after example. In fact, I just had one recently where I had a client that I did an estate plan for.
Yep.
They have a child in their second year at Michigan State.
Yep.
And that child was in an accident. And
Okay.
that child was taken to Sparrow Hospital.
Okay.
The parent finds out about it here in Oakland County,
Okay.
goes over to Lansing,
Yep.
shows up at the hospital, and the hospital says, we cannot disclose
Yep.
that your child's here, let alone their condition.
Yep.
And you certainly are not making medical decisions for that child
Yep.
unless they have a power of attorney in
Yeah.
HIPAA place. And so, yes.
Isn't that a rude awakening?
That is a
surprise?
rude
Yeah.
awakening. So
Yeah.
when you are over 18, no one has the
Yeah.
legal authority to make medical decisions for you any longer.
Yep.
And what I love hearing from clients is, but they're still on my life and they're still on my health insurance.
Yeah, there you go.
And my response is, you're just the poor fool paying the bill,
Yeah.
but you have no access to medical information.
Yeah.
Right. So having those for your teenagers is extremely important. You
Yeah.
know, powers of attorney, I like to say, are like
So how do you just, as soon as they're 18, what does somebody do?
in my case, my clients call me.
Yeah, okay.
And they say, hey, my kid's an 18-year-old at Western Michigan. I want to get a power of attorney in place. Great. When are they coming home?
Yeah, okay.
And we'll do it.
Yeah.
In my opinion, powers of attorney, it's very similar to homeowners insurance. Not the way it's set up, but the concept being,
Okay.
we are pretty fortunate here in Michigan that we don't make a lot of claims on it. We don't have, hurricanes. We don't really have bad weather per se where we're making claims. Okay. So you may pay $1,000 a year for your homeowner's insurance. Over 30 years, $30,000 later, you have never made a claim. But you happily paid that every single year in case your home burned down because you knew they were going to replace it.
Yep.
Powers of attorney, if you are lucky enough to go through life and never need help signing a check, filing your tax return, signing a deed, making your own medical decisions, then I guess those powers of attorney didn't do anything, just like your homeowner's insurance didn't do anything.
Okay.
But if you ever need someone to sign a deed on your behalf, make medical decisions for you, it is much better to have them in place than to not, because not means Now we're dealing with conservatorships and guardianships in probate court.
Okay.
When we could have avoided it by just having those 3 documents in place.
So say you got the document and you put it in your drawer somewhere.
Yeah.
So and you're incapacitated.
Yeah.
How do you take it out of your drawer and give it to the person to go use it?
You know, we touched base on this earlier regarding the estate plan.
Right.
I recommend that my clients have their powers of attorney, when they get their electronic powers of attorney, that they send them to their patient advocate, to their agent in fact for the durable power of attorney. So if those individuals, first of all, they should probably know that they are acting in that capacity, because like you said, some people don't even bother telling anyone.
Yep.
Now they know, hey, if mom and dad are in the hospital, you are the patient advocate.
Yep.
You have the document. A copy is all that's necessary. They do not need an original to act.
Okay.
So if something happened to mom and dad and they're in the hospital, they can go on their computer, print out that healthcare power of attorney, and bring it to Beaumont.
So what if I choose one person? Because I think sometimes people don't do it early because they're like, well, later on it'll probably be my kids, but right now it'll probably be my, my sibling or something, or my friend, and they're thinking about when they're going to change it.
Yeah.
So that would be like a comfortable change.
Yeah.
But there's an uncomfortable change where you don't trust that person anymore that you once had signed up.
Yeah.
So how do you deal with it if you change your mind? And how does that person that has that document that you gave to them, is that no longer valid?
Yeah. So I typically don't see people making changes because they don't trust that individual to make those decisions anymore. It's usually like the example you just gave out. When I prepared these, my kids were 16 and 17 at the time.
Yep.
Fast forward a decade, they are now old enough to do this, so I'm going to update and redo my powers of attorney.
Yep.
At that point, do you need to tell the individual who was your power of attorney that you signed new ones? You don't have to. There is a provision in the new one that clearly says this revokes anything that was signed prior to this.
Do you name the person that it revoked, or do you usually use a generic?
It's just generic.
Okay.
Correct. It's not a bad idea to tell that individual, hey, my children are older, I've created a new power of attorney, the one I emailed you 8 years ago, delete it.
Okay.
It's null and void. It's not going to work anymore.
Okay.
So yeah, now one other thing I like to do or advise my clients to do is I like for them to bring their healthcare power of attorney and HIPAA release to their general physician. So if they are a participating in Ascension Health or McLaren, whatever health system they participate in, that physician will make a copy, upload it to your file.
Okay.
So now it's in the McLaren system. It's in the Ascension Health system. So I like to my clients to actually have those documents in the My Chart.
Okay.
Yeah.
All right. So those living documents now, will and the trust.
Yep. Post-death. So typically, again, husband, wife, 3 children. When we're dealing with minors, we're always having to do a trust, right? Minors cannot inherit more than $50,000, or anything in excess to that becomes a problem if a minor inherits it and will require a conservator. Okay. Most people, between life insurance, 401k, the value of their home, they're going to have more than that if they pass away. So the only way to deal with that issue is through a trust.
Okay.
Your children, your minor children, are able to receive an inheritance through a trust without a probate court getting involved.
Okay.
So when we have minor children, it's a no-brainer.
Okay.
We have to do this, okay? You're not going to name a 4-year-old and 5-year-old the contingent beneficiary on $1 million 401k.
Okay.
That is irresponsible. If you and your wife die and now you have a 4 and 5-year-old that just inherited $500,000 each, have 4 and 5, they can't do that, right? When it comes to adults, that really gets a little bit more nuanced. Do you need a trust to avoid probate court? No, you don't. Is a trust maybe a smoother administrative process when you pass away versus not using one? Yes, typically it is. And I can point to 2 examples that really illustrate the difference well. Some people will ask me, do I have to do a trust in order to have my assets avoid probate court and go to my loved ones? And the answer to that is no, you do not. You can have a POD, a pay on death on your, let's use a checking account for an example. You can have it's a jointly owned account between a husband and wife, and you can have your 3 children, the POD beneficiaries on that account. When husband and wife pass away, that account will go to those 3 kids. It has avoided probate court, and it went to the people they wanted it to go to. Okay? That's mission successful from that perspective. However, is that the easiest way and the smoothest way when it comes to the administration? Not always. So if you have a POD to your 3 children, I like to say you've put the cart before the horse. Mom and dad pass away, the children bring the death certificates to the bank, and the bank looks at the 3 kids and say, Mom and dad had $12,000 in their accounts. Here's your 4, here's your 4, and here's your 4. However, who paid the funeral? Who paid the burial? Who's paying the gas bill, the electric bill, the dumpster, right? Filing the last tax return. Who is doing those things? It is every man for themselves at that point. Once you give someone money, you cannot tell them what to do with it. And kind of going back to where we were talking earlier, post-death is where all of the issues come out. So this is where we see I can't contribute the third to the funeral and burial because I just had an IRS tax bill come and I have to pay this off. I can't contribute my third to the utilities. Why don't you do it? When you got divorced 4 years ago, Mom and Dad let you live for free with them. Then I never lived for free in their home, so you pay it. So now we get a little bit of the back and forth between siblings. So yes, you avoided probate court, but these kids hate each other. Where if you used a trust, it would have been smoother. You have
Clean it up
the
up
trustee.
front.
I have access to the liquidity. You don't get your third, you don't get your third, and I don't get my third. I'm using this for the funeral, the burial, the luncheon, all of the administrative expenses. When the administrative expenses are done, then I will distribute the money. So now we don't have kids hating each other. You didn't pay for this, you didn't pay me for that. There's no one's getting anything until business is done. I think another good example is a home. If the goal is to avoid probate court and make sure your house goes to your 3 children, we do not need a trust to do that. We can do a ladybird deed that says when Mom and Dad die, this home goes to their 3 kids. Okay? But I like to say, if your 3 kids were in the room with us, and no one's feelings will get hurt by answering this question honestly. If I looked at your 3 children and say, would the 3 of you right now go out and buy a rental home together as 3 partners in a rental home, the 3 of them are going to say, absolutely not. I do not want to own a rental home with my brother and my sister. By preparing a deed that says when I die, when we die, this house goes to my, that's essentially what you have done. And now we run into the, I want to sell it, I don't want to sell it. I think we should keep it as an Airbnb. Let's not list it until the spring. I don't like the real estate agent you're using. You have 3 chefs in the kitchen. And it is very difficult, if one of them isn't willing to play ball, to get a court to force somebody to sell an interest in real property. When you have a trust, again, it takes that out of it. I am the trustee. I will get a fair market appraisal on this. If you want to buy it, you can buy it. If you can't buy it, we're selling it. And when I sell it, you get your third, you get your third, and I get my third. So you don't have these issues. And a lot of times, it isn't always the kids. It's the in-laws who are creating problems for the kids. Because spouse at home is chirping, why hasn't your brother done this? Why haven't they do this? Why aren't they doing that? And so inevitably now you're going to your brother and you're arguing over it. So I tend to see those sorts of family issues are taken out of the equation when we're using a trust.
Explain the origin of the ladybird.
So I hope I'm doing this correctly. My understanding, it is named after Lady Bird Johnson, President Johnson's wife. I do not know the background as to why she came up with this concept. I know,
Ryan, you want to look that up?
Yeah, that would be great. I know.
Well, I'll throw Ladybird out there.
I know that it's named after her. And it's essentially no different than if you go to your bank and you add a death beneficiary on your bank account, that's exactly what the deed is doing. It's saying that you own it, and when you die, it conveys to a trust,
somebody
to
else.
Individuals, to some entity or individual. So you're putting a beneficiary.
We always throw Ladybird out there, but what it means for somebody who hasn't heard of it, it's just assigning who owns it after you die.
You're putting a beneficiary on your home. Because I like to tell people very bluntly, deceased individuals cannot own real property without a court getting involved.
Yeah.
So you need a beneficiary on your home when you
Got
die.
it. So unlike
Yeah.
at the bank, you could put a TOD.
Yeah.
Yeah, the Ladybird does it
Is
for
basically the TOD for your home.
Yeah, I got
It's
it.
one way to look at it.
Yeah.
Yeah. Yeah.
That's exactly what it says.
Yeah.
On mine as well.
Yeah.
It's automatic.
But it doesn't say why
Yeah.
she came up with this.
I don't remember
this
why
idea.
it was her. Or what
Yeah, me
happened,
neither.
but There is some story behind
Yeah,
it.
I'm sure there's some nuanced story to
Yeah.
why what she did. But yeah.
Yeah.
So in on the topic of deeds,
Yeah.
you know, we kind of went through some examples here of maybe some overzealous drafting.
Yep.
And some provisions in trust that don't seem kosher. I see all sorts of it. We touch base on powers of attorney. We touch base on a few other things. I see other issues created when people don't meet with estate planning attorneys
To have nothing.
that have nothing, or they get ideas for workarounds.
Got it.
And the biggest example of that I see regularly is with deeds.
Deeds.
Correct.
Yeah.
People all
Like
have,
changing a current
well,
deed.
I'll give you an example.
Yeah.
People have all heard the issue of when my mom and dad pass away, their house is going to be most people have heard this. Their house will be a probate problem if it's not addressed.
Yeah.
So dad passes away. Next door neighbor gets into mom's ear and says, hey, if you didn't know this, when you pass away, your kids are going to have a probate problem unless you do something with your deed.
Yep.
So go have someone prepare a deed and add your kids to the house.
Yep.
That avoided probate court, absolutely. But it created all sorts of other potential liability issues, and it certainly can create tax issues
Yep.
that people are
So
unaware
just give
of.
it. Yeah.
So consult with somebody that knows what
Yeah, but
they're
what, like,
doing.
what's one of the tax issues?
Yeah, so I see this often. Dad, mom purchased a home in 2000 here in Bloomfield Hills.
Right.
Dad passes away. Somebody next door neighbor gets in mom's ear. You need to do something about this house in Bloomfield Hills or it's going to be a probate problem.
Yep.
So she just contacts anybody that knows how to prepare a deed and has her 3 kids added as joint tenants with rights of survivorship on her deed.
Right.
And that is done in 2005.
Right. So now
When-
four people own
So
it.
now you got 4 co-owners on a home.
Yep.
That effective in 2005.
Okay.
That house was worth $100,000 in 2005.
Yep.
Mom lives another 20 years.
Yep.
She passes away in 2025. Those kids have never lived in that home.
Correct.
That is not their primary residence,
Mm-hmm.
so they don't get the exemption. When mom passes away 20 years later, that home is now worth $400,000.
Yep.
Those 3 kids have been owners, even though they never lived in that house.
Yep.
From 2005 all the way until 2025, that is a $300,000 capital gain that they will pay taxes on.
Yep.
A ladybird deed allows you to get that step up in basis.
Right.
So the kids would actually inherit it at $400,000, and if they sold it relatively soon, they would pay nothing in taxes versus a $300,000 tax burden. That is all through simple language on a deed of someone making the wrong decision.
Step up in basis, one of those beautiful
Yeah.
words
Correct.
in finances and
Yeah.
inheritances.
And portability.
Yeah.
You taking your spouse's exemption and porting it to yourself.
Yeah.
So, and there's been some discussion, and I'm sure you have seen this, where the estate tax exemption, roughly $23 million and some change.
Yep.
There is a sunset provision in that law that says if Congress doesn't address it at all in 2025, effective 2026, it will drop.
Yep.
$7 million, $14 million with portability for a joint married couple who files
Yep.
jointly. Before that portability law came in and when that estate tax exemption was low,
Yeah.
it was problematic. And that's
Yep.
where we used to have to do these $10,000 trusts because we were dealing with tax
trusts,
planning,
yep, yep.
AB trust, family trust, whatever islets.
Yep.
Because the estate tax exemption has been high for so
simplifies
long,
so much.
it has put everybody, virtually
Yeah.
99% of us,
Right.
in the same box.
Right.
And again, kind of go back to what you said, when people are throwing these kitchen sink trusts out at people,
Yep.
the estate tax exemption isn't an issue anymore. The individuals have not enough. There's all sorts of reasons why those trusts do nothing for them.
Right.
but we see it happen.
Yeah. So step up in basis
Yeah.
is where you inherit the asset at the value that asset is worth at the time the person passes
Correct.
away.
Correct.
Versus what they may have paid for it. And it goes with
Correct.
homes, and it can go with
Stocks. Yeah,
and-
that's a big one that we
anything.
see.
And I've seen some crazy stocks at worth $400,000 at a basis like $10,000 that've
Yeah.
been around for like ever.
And those
You know?
individuals will not cash that out
Yeah.
because they don't want to pay the tax on
Right.
it. So they'll pass it to their children so they can get the basis.
They
in
get
it.
they inherit
See
that
it all the
400
time.
grand.
Yeah.
So I've also seen it spouse to spouse, and that's most people never plan around that.
Yeah.
They never think about that. And where I've seen it mostly is where a spouse inherits, say for example, like private ownership in a business, and one spouse passes away that owned a business,
Yeah.
and the other spouse didn't have any ownership in that business, and then they inherit the proceeds of the sale of that business
Yeah.
at the check that was paid to buy that business,
Mm-hmm.
instead of
What the
having any
business was worth.
gains
Yeah.
about, because it was all sweat equity.
Yeah.
You know what I mean?
Yeah.
And so I see it within a married couple as well.
Yeah.
But very rarely, because most people own things jointly.
Correct.
And stuff like,
Yeah, yeah.
But,
That's a
but
great
that
example.
could be a phenomenal.
Huge.
Yeah. I mean, you think
Huge.
you're going to pay hundreds of thousands of
Yeah.
dollars of taxes,
Yeah.
and all of a sudden.
And again, I guess the caveat to this conversation would be is that can always go away depending on what Congress wants to do. Right,
Right.
now, that law sticks. I don't think
Yeah.
there's an appetite to get rid of it. But yeah, step up in basis,
Yeah.
portability. Those are great things.
You know, there are like, especially for businesses, like you see sometimes people own, they have ownership in the non-publicly traded company they work at. They may have gotten up to executive
Yep.
levels or something like that,
Yeah.
and they've got stock options or phantom stock or whatever you want to call it. And but whenever they can, they typically put their spouse on it, because that's
Yeah.
just normal. That's what
Yeah.
we do. We got joint bank accounts.
Yeah.
We got joint this, joint that.
Yep. And if they're not able to, then we
Yeah.
also will assign
Yeah,
their interest to their trust.
But then they don't get that step up in basis if they this natural reaction to want to own everything jointly. Sometimes you need to rethink that.
Correct. And you gave two.
Depending on what it
You
is,
gave
yeah.
two. The sole member LLC
Yeah.
versus doing a multi-member with your spouse. What is the point of doing that?
Yeah, right.
Like you just illustrated,
Yeah.
why not keep it a sole member? So when you pass it on to your spouse, they inherit it at the value of
Right.
that business at that time.
Yeah.
Yeah. Yeah.
What else you see out there? You got any other mistakes or?
Yeah, deeds are the big one. Lack
Oh, here's
of-
one on the deed.
Yeah.
I've seen this. You probably have two. 3 kids.
Excuse me.
They only put one on, and they say because they know I want it to.
Because
go to
little
everybody.
Johnny's going to do the right thing.
They know I want it to go to everybody.
Correct.
Even if little Johnny does do the right thing, how does that complicate things?
Yeah, so there's a couple of things. Yeah, so deeds are always the big one. And I just touched a bit. You just brought up another point.
Yeah.
So when you put little Johnny on the deed, one of the children with mom,
Yep.
now mom just took on little Johnny's liability.
Yep.
And maybe he's not out drinking and driving and acting, reckless.
Yep.
But what if little Johnny's wife files for divorce 3 years from now?
Yep.
They're not going to take mom's home from her, but Johnny appears to have a $400,000 asset that he really doesn't have.
Yep.
So now when he goes through his divorce judgment, his soon-to-be ex is going to get a significant more money because he owns a $400,000 home.
Yeah.
Even though was never the intention.
Right.
The other issue, and this isn't so much an issue now, is gifting.
Yep.
So if Johnny does the right thing and mom dies, and again, if it wasn't a ladybird deed, he's going to end up with that step up in basis or not get a step up in basis, pay that capital gain.
Yep.
But let's say he sells it, pays the capital gain, and he gifts his family money. Well, if it's over the gifting threshold, which I think it just went up to 18 or 19,000, then not a big deal. But you have to tell your accountant, and your accountant needs to file a gift tax return on
Yep.
your behalf, right? And so these things have to just be done, and most people aren't doing that. They're just, here's a check for $40,000 to this brother, $40,000 to this brother, $40,000 to that brother, over the giftable amount that you're
Yep.
allowed to do, and they haven't filed the right gift tax return, And so now they have potential IRS issues.
Yep.
So there's all sorts of problems in adding kids to deeds.
Yep.
Not just the tax issue, the liability issue, the gifting issue. There's several issues in doing
Yep.
it. Yeah. Or the simple one, you give it to little Johnny and he doesn't do the right thing.
Yeah.
And he takes it and he sells it and he keeps the money.
Yeah.
And he has every legal right
Yeah.
to do that.
And it's complicated to do the right thing even anyways, because
be.
not ethically, but you own something and now you have to dismantle
Yeah.
that ownership and give the proceeds to other people that didn't own it.
I see that often with kind of your older school clients.
Yeah.
Who say, I put my oldest son on everything because
Yeah.
that's the way you do it.
Yeah. So
And-
basically,
yeah.
whatever they would put as an executor, they just make own everything now.
Correct.
And just assume they'll execute it out.
It's
to
going to work
everybody
out.
else.
It's
Yeah.
going to work out
Yeah.
perfectly when they
Yeah.
pass away.
Yeah.
And unfortunately, I very rarely see it work out the right way.
Okay.
Yeah.
Yeah.
Yeah. Other downfalls of estate planning that I see, again, not having them. Minors, having minors as beneficiaries. God
Yep.
forbid something happened to parents and they don't have a trust.
Yep.
They've created all sorts of legal issues for their kids for many years.
Yep.
If kids are irresponsible,
Yeah.
maybe they're having bankruptcy, they've had fiscally irresponsible. They've already gone through 2 bankruptcies by the time they're 30.
Yep.
If you pass away and you give money to this 30-year-old who's on their second bankruptcy, there's a good chance they're going to be
Yeah.
in trouble again. So using estate planning tools to kind of regulate someone who may be fiscally
Even if
irresponsible.
they are responsible, man, anytime I've seen people receive money more than once, they make better decisions the second time.
Yeah.
And so, even if somebody is doing great, and at age 25, just throw an age out there, they received, all of their money, versus if they got money at age 25 and 30, and maybe even 35, they would make better decisions
Absolutely.
the second time around, 9 times out of 10. That's what I've seen.
Yeah.
Just because we get some experience.
Yeah.
And it's not as much of a shock. It's not as emotional. It's not a lot of things.
Yep. And on that note, I like to tell clients that even if you have the most responsible 22-year-old in the world and they are not going to go blow it, they have no idea how to manage $1 million inheritance. They don't know why would they know how to invest it to get the most they can? No, what happens is they have $1 million in a checking account.
Yeah. I wouldn't have had a clue.
Right? And so, again, it's not that we're worried about what they're going to do. We're also worried about what they're not going to do with their money.
Yeah.
So that's,
And then hopefully you picked a good trustee and they'll sit there and be a good guide, a good mentor,
Yeah.
a good educator for a few years.
Yeah, absolutely.
Yeah.
Yeah. And that's why I like to tell people you're appointing a trustee because you trust them to
Yeah.
do the right thing by your family.
Yeah.
And and if you don't, then if you don't trust them, then they're not the right
Yeah.
person.
Yeah.
Another thing that I see is kind of an issue where people really got to think about estate planning is, again, with minor children.
Yep.
If you want to say, if you pass away and your spouse pass away with minor children, if you want to say in who becomes the guardian of your children, you have to have a will. If you do not have a will saying who you want to appoint as your guardian, then it will be up to a court to decide who watches your kids. And it may not be the person you wanted to do it, but that ship has sailed.
Yep.
So that is another big thing I see, is people not understanding
Yeah.
that it's just my mom and dad will get my kids. Well, no, they don't
Yep.
just by default. Get your things. The other thing that is a big reason to have a discussion with an estate planning attorney are blended families. Blended families by accident disinherit children regularly. And the example would be the following. Husband and wife are married. This is their second marriage. They each have 3 children from their first marriage. They do not have children together. They are both on their home here in Bloomfield Hills. They have no estate plan. Husband passes away, and now the home is in his surviving spouse's name. She now passes away a year later. They have no estate plan. Their home goes through probate court. And the law of intestacy, the default law, controls. And her 3 children get the proceeds to
Interesting.
that home.
Yeah.
And the spouses, the deceased spouse's kids, get nothing.
Yeah.
Okay?
Completely
and so just
unintentional.
Unintentional
Bam.
disinheritance
Yeah.
because these were not their children
And
together.
the kids got to deal with that for the
Correct.
rest of their
And
life.
updating
Yeah.
estate plans.
Yeah.
Again, problematic.
Yeah.
I think on the notion of kids, Kobe Bryant just made this mistake before he passed away.
Okay.
He did not update his estate plan to include his last child. So she was not a beneficiary under his estate plan.
Don't they
And
usually say all
it became a
living kids?
massive legal issue. No, they were named as children.
Oh.
Specifically named.
Okay.
And the last one that he had, he never amended, never included.
Okay.
So was not a beneficiary. Now they have been unwinding this through court, but again, just not updating a beneficiary with life changes
Yeah.
can be problematic.
Yeah.
Can unintentionally disinherit
Yeah.
children. Yeah. Yeah. There's example after example.
That's tough.
Yeah.
So, as a parent, when your kids are minors, guardianship, no brainer. Kids turn 18, power of attorney
for
patient
them.
no brainer.
Yeah. Yeah. I always tell people, if
Yeah.
you own a home
Yeah.
and or you have minor children, you have to do an estate plan.
Yeah.
It doesn't necessarily mean that you have to do a trust. One
Yeah.
example would be a married couple with one single adult child in their 40s.
Yep.
There's very little reason to do a trust for that sort of family dynamic. So it doesn't mean that we're always defaulting to a trust.
Yeah.
It just means they own a home. They have to do something.
Yep.
So home ownership, minor children are always triggers.
Well, I always believe,
Wealth is a choice. Boom.
and you got to get educated to
Yeah.
know how to make the decisions.
Yes.
There's a lot to unpack with estate planning,
Yeah,
for sure. We'll have to talk again
for sure.
and
Yeah.
get into some more.
We can go into celebrity mishaps
Yeah,
for
let's do
a
it.
while.
All right.
Awesome.
Thank you, Joe.
Thank you, James.
Appreciate you,
Appreciate
buddy.
it. Yeah,
All right.
appreciate it.
Ta-da!